what this lawsuit is all about, and I guess start at why you chose to publish the OCGA, the Official Code of Georgia, annotated online.
There's only one law in Georgia. It's the Official Code of Georgia Annotated. Every act in the Georgia Assembly begins an act to amend the Official Code of Georgia Annotated. So we purchased, scanned, and posted the Official Code of Georgia Annotated because that's the law.
Right, and so we'll get a little bit more into the details of the lawsuit, but what's interesting is, ignorance of the law is not an excuse for breaking it. If I get pulled over for missing something that I'm supposed to have on my car, I can't say to the police officer, oh, I'm sorry, I wasn't aware that I was supposed to have that or that it was illegal. And if ignorance of the law is not an affirmative defense, then we're all required to have access to the law. And as you pointed out, the A in OCGA is annotated, and that is what a judge will rely upon, is the case history and attorney general opinions. It really is more than just the code. The annotated code is really the law, right?
Well, again, there's only one official law, and it happens to be annotated. Now, if Georgia had made something else the Official Code of Georgia unannotated, that's what we would have bought, purchased, and scanned. But there's only one law, and it's annotated.
Right, that makes perfect sense. So is the premise that this is an official public document, and therefore the public should have unfettered free access to it?
In America, edicts of government are the law, and that's court cases, that's regulations, and that's statutes. And America is based on the idea of an informed citizenry because ignorance of the law is no excuse. If you don't know what the law is, you can't obey it, but also you can't change it. And America is based on the idea that citizens are able to read the law and go to their legislature and say, I don't like it, we should do something differently. Okay, we're set.
Looking good, looking good. The legislature's response is that, yes, these things or rather the Code Commission's response would be, look, the law is public, we agree. The court rulings are public, we agree. The attorney general opinions are public, we agree. But the annotations, when put together, that sort of gluing together these public elements somehow creates an artistic or creative work that is intellectual property. Does that pass the smell test?
Well, it doesn't, and the reason is states are allowed to assert copyright. If there's a Visit Georgia tourism video, they can copyright that. But in America, you cannot copyright edicts of government. You cannot copyright the law. And the Official Code of Georgia Annotated is published by the state of Georgia. Copyright is asserted by the state of Georgia, and it's by the Code Commission, which is an agent of the Assembly. This is as law-like as you can get. It is an official statement of the law of Georgia. It has no copyright.
Right, and so this is also interesting, and it sort of has a corollary to the other story we're working on, is that the legislature and its subordinate elements, if you will, like the Code Commission, they're essentially exempt from their own open records law. And as you know, we requested a copy of the OCGA because we wanted to inspect it, duplicate it with our own equipment, and then publish it on a news website. I mean, this is about as First Amendment as it gets. And we were told basically that we would do so at our own peril, that we did not have the permission, and that we may face a similar lawsuit that you're facing. What do you think about that?
Well, the state of Georgia's position is, hey, we got a website, what's your problem? And here's the problem. They can have as bad a website as they want, or as good a website, but having lots of different websites with the law is really important. Maybe you want to do the law of journalism in Georgia and Mississippi and Arkansas and compare them. And you ought to be able to build a website that compares those. I want to do all 50 states. I know legislators want to be able to look at the law for specialized purposes like attracting business into Georgia. And you know, if you're going to open a factory in Georgia, you need to know what the law of Georgia is going to be before you invest millions of dollars. So making the law available is partly about democracy, but it's also about our economy and about business. It's about public safety, right? Building codes are the law. And this is, again, really important. These are the rule books that we govern ourselves by. And in America, the law isn't owned by governments, it's owned by the people, because it's the people that give authority to the government to operate. The people own copyright on the law.
And that's a really good point, is for the state to assert copyright, the copyright is the people, and therefore shouldn't the people, since the government is of by and for the people, shouldn't the people have the free, not only access, but free ability to duplicate if necessary?
There's a document that the U.S. Copyright Office puts out called the Compendium of Office Practice Procedures. And one of the clauses in there says that for reasons of public policy, edicts of government, the law, are not eligible for copyright in the United States. And they list a whole bunch of court decisions that have gone over that issue, for Supreme Court decisions, for state regulations, for building codes. And again, it's because ignorance of the law is no excuse, and our democracy is based on citizens informing each other.
One of the things that the Legislative Council said in Georgia was that we were free to inspect the document. First off, he said, we're exempt from open records, so your request is turned down on that alone, but that we were free to inspect the OCGA at our nearest library. Is that sort of 20th century or 19th century thing? And because the library today is the internet to a large extent, and if we can't access the OCGA online, then we have to pay $380 to buy it, or we have to physically go down to the library, which is, it's almost like prevents access. What do you think of the answer, the official answer to our TV station, go to the library?
Well, when we scan the books, the same books you would get in the library, we posted them on a site that has optical character recognitions and a search engine. So you can pull up a volume, you can search for crosswalks and schools, and it'll show you every single page in that volume. Now, you try doing that with a paper copy in your library. You can't, search it. You can go find an index, which might help you, it might not. It just doesn't make sense in an internet era to say you need to travel 30 miles to the county seat to look at the 50 volumes of paper, and that somehow is making the law accessible to you. It isn't.
Good answer. So the other thing is that it's interesting that the state could have, for the lack of a better term, abandoned the copyright and transferred it to its vendor, LexisNexis. But instead it maintains the copyright of the Code Commission, and it's the state of Georgia that is suing you. The Code Commission is suing you. It's not the publisher. Is that an important distinction?
I want to be very clear. If this had been a private work, there is a Westlaw unofficial compilation of the Code of Georgia that they put together with the sweat of their brow, and that is their commercial product. That's not what we're talking about here. We are talking about the one and only official law of the state of Georgia. And the fact that they hired a vendor, Lexis, to do some of the work for them doesn't make anything different. It's still the official law. And that's what we care about, is the official statement of the law.
Right, and their answer, of course, is that part of that vendor agreement is that they publish the code unannotated. Is that far enough? And even though it's a clunky website where you kind of have to know what code section you're looking for, it's kind of a game of go fish, but just publishing the unannotated code, does that provide the law as it applies to the people of the state of Georgia?
Well, the unofficial law that is up on the Lexis website that the Code Commission points to, there's two problems with it. One is it is not the official Code of Georgia annotated, which is what the Assembly, when it passes an act, that's what it amends, right? It doesn't amend the unofficial. But more importantly, as a citizen of Georgia, if you try to access that website, before you can do that, you have to click, I agree to the terms and conditions. One of the terms and conditions is if you have any issues that happen, like you used too much or you violated the terms, you've agreed to a New York court to adjudicate your dispute. The terms of use say that you will not copy this material, you will not redistribute it, you will not redistribute it for, quote, nonprofit and public purposes. And so you are prohibited from speaking the law. You can sort of read an unannotated version of the code, but it isn't the official code of Georgia annotated. And again, you're being told you can't speak the law. And this isn't about reading the law on somebody's website. This is about my nonprofit being able to speak the law to inform my fellow citizens about what their rights and obligations are in our democracy.
Is the state of Georgia asserting some material damage here?
No, the state of Georgia is not asserting damage. They're looking for an injunction. If they had asserted damage, of course, I would be entitled to a jury trial.
I see, and that's probably an important distinction as well, because really they just want injunctive relief. They just basically want you to cease and desist and stop. What was the first notice you got from Georgia? Was it a cease and desist letter or a takedown letter, as we call it in the business?
When I purchased the code, the very first thing I did after I scanned it, is I put it on a George Washington thumb drive and I sent it to the Speaker of the House of Georgia and said, look, Georgia law is available. Isn't this great? And soon thereafter, I got my first cease and desist letter. That was in 2013.
I see. And you've had some success in other states. Is that accurate, where you've published the law and you've prevailed, correct?
Yes, my nonprofit attempts to put the law online, generally speaking. So we've done building codes for the country. We did all the Court of Appeals for the first time. In the 90s, I was responsible for the U.S. Patent Database, Securities and Exchange Commission. For the law of states, we had the Oregon revised statutes online, and we got a similar takedown notice. And there was a lot of blustering back and forth, and finally I got a call from the Legislative Council of Oregon, and they said, why don't you come on up, we're going to hold hearings. And they held hearings, and they listened to me, and they listened to a whole bunch of citizens from Oregon, and they listened to the Legislative Council, and everybody thought about it, and they thought about the fact that this copyright assertion was from the 1940s, and they unanimously waived copyright because it was the right thing to do. And that's how this dispute should have been settled. I've tried many times to discuss this with the Code Commission. Every time I send them a letter, I say, can I please come to Georgia? Can I come to Atlanta and appear before the Code Commission? Or can we have a phone call? And we have not had a single conversation. It's been these takedown notices and then a lawsuit. And that's the only state in the country that's filed suit against us.
This is kind of dovetailing with a bunch of issues we're dealing with. Every time we put in an open records request to the state of Georgia, particularly to the General Assembly or any of its, subordinates, a staff member, if we want the emails of a staff member who is communicating with a vendor, we want to see those emails. The answer is always no. If we want to see any constituent communications, they won't even give them to us redacted. The standard answer from the Legislative Council is, we are exempt under the Open Records Act. Whether that passes any legal test or not, and it appears to pass a legal test, does it pass the test of living in an open government, open society where we're a government of, by, and for the people, when our representatives refuse to give access to their most basic records that they've required agencies to provide in every other circumstance?
It was Louis Brandeis that said sunshine is the best disinfectant. I am a firm believer that you can disagree with someone about what the law should say, but by having that information out there, and remember the law and the proceedings that led to the law, so the letters with the vendors and things like that are an important part of that. If we know what transpired, then we can discuss our differences and we can come up with a better public policy. That's why you want transparency and open records. It makes for better government.
It's kind of a sweetheart deal for the state, and you could argue by extension the taxpayers, that the state gets things for free in return for allowing Lexis to make a profit off of everybody else. Is that accurate?
The theory is that if the state did the codification itself, or paid the full freight for doing it. It would be very expensive, and that by giving Lexis an exclusive right to sell the law, they can get a return on their investment. But you know, there's no free lunch. This isn't Georgia getting some super deal. Georgia would do the law no matter what. They would use contractors. Many municipal codes are done the same way. There's a vendor that does the codification, but with the municipal codes, we've seen the city of Chicago, District of Columbia, San Francisco, Philadelphia, all put their municipal codes online, available in bulk. And you know what happens when you make the data available in bulk? I've seen this happen all across the country. Volunteers from that area go in and they put together a far better code. And again, Lexis can build whatever website they want. It can be a good website, it can be a bad website. But when you make the raw materials of our democracy available, volunteers go in and they make far better websites, things that people can use, that work on your iPhone, that work if you are visually impaired, right? The Lexis site is really tough to do if you are blind. It is very, very hard to navigate. And we shouldn't be prohibiting people from having that kind of innovation. Again, this is partly democracy, but it's also about innovation, about making the law available not just for citizens, but also for lawyers and state senators and members of the assembly. If they have a better way of reading and navigating the law, they're going to make better public policy. They're going to make better court cases.
You know, what's interesting, we asked to interview the Legislative Council on this issue. And the Legislative Council, who, by the way, has replied directly to us on every one of our open records requests, even when we made them of a member of the General Assembly, has said, "Oh, I'm not a public official. I'm a private attorney, and my client, to whom I have fiduciary duties, is the General Assembly and the General Assembly alone." We have in writing the Legislative Council basically saying he doesn't work for the people; he works for the General Assembly. Of course, I sent him a copy of the U.S. Constitution, the Georgia Constitution, and some others that indicated the first line of the preamble is "We the people." It does kind of come back to it kind of ties together all of these issues of transparency and the lawsuit you're involved in now, in that the Legislative Council, the one who's really the other party, if you will, is really believes that he doesn't serve the people. I mean, am I making it too? Am I speaking too much in hyperbole, or do you think the Legislative Council is sort of, in this case, and in the response to us, acting like a private attorney rather than a public official when the people are paying his salary?
So typically, a private attorney would not speak on camera about one of their clients, right? I know if my attorneys were to get a call from you, they would say, go talk to Carl. The Legislative Council is a hybrid position, and it is in the middle of litigation, so it is not unreasonable for an attorney in the middle of litigation to explain why they sued, or to say, but go talk to the chairman of the Code Revision Commission, a senator or an assemblyman. So the fact that he won't talk to you, he is a lawyer for the legislature, and that is in fact his client, and I do buy that. On the other hand, he runs an important office that publishes the Code of Georgia, and that puts him in a somewhat of a public position. So I'm conflicted on that one.
Yeah, I mean, he won't even talk to us about turning down our open records requests on other issues where we've said, we just want you to explain it to us. And he's saying, sorry, I don't have to talk to you.
Well, then the question is, who should you talk to? If it's not him, who?
Yeah, and I think you're right. I think we have to go to the chairman of the Code Commission next to see about that. Is there anything else we're missing about your lawsuit in particular, or about this issue in general?
Georgia's the first state to actually sue us over putting a state law online. We've had some takedown notices from Mississippi. There's a half dozen states that play this game of asserting copyright and saying you can't use the law without a license. I found the court case to be somewhat unreasonable, particularly the allegations of a strategy of terrorism. And as our attorney said in the answer, we found those allegations to be gratuitous, defamatory, and bizarre. This is something that should have been solved by the citizens of Georgia speaking with their elected representatives. This is clearly an issue of the internet era. Can we publish the law more effectively? there should have been hearings, not a lawsuit. And I still hope we get to that point, because this really is the kind of thing that people should be talking about. How can we publish the laws of our country in a more effective way?
Yeah, excellent. Anything else you want to add you think is important?
No, I think that's it.
All right. Before I let you go, I don't know if it passed yesterday, but the General Assembly in its final session was dealing with a bill that had gotten all the way to a final vote, and it would there's a judicial qualifications board in Georgia that basically is the arm that investigates and punishes judges when they
Yeah, I'm familiar with that.
So, well, apparently someone was able to get through a bill that would make secret the Judicial Qualifications Board proceedings and would seal any investigation that did not result in an action or like a disbarment or some specific action punitive against a judge who had broken the law. They say that the judges need to be protected from this kind of malicious, sort of, or false allegations. But again, we have here a General Assembly that's considering the concept of, even a public official like a judge, a very powerful public official like a judge, that we shouldn't be able to see the proceedings and we shouldn't even be able to see the investigation unless some action is taken.
So I'm off the record here, but I don't know if I'm serious. But the chairman of the Code Commission revision used to be a senator, but it's now an assemblyman who used to be a judge and was disbarred under the judicial misconduct proceedings. So just so you are aware of that.
I'll check that out.
Okay.
It's again indicative of this concept. I will tell you there's one other thing.
So I'm back on the record now.
Sure. I wanted you to be aware of it, and I don't know if it's passed yet, but it's sort of the idea that this is a priority, is, that there's actually a bill to keep secret certain proceedings involving judges. I mean, it speaks to the priorities of the current General Assembly, that they're more interested in opacity than transparency.
Well, we're being sued for the official law. There has been a dispute on whether the regulations of the state of Georgia are under copyright or not, and there's actually a lawsuit pending in the Georgia courts over that. The building code of Georgia is, some people maintain, under a copyright. And I know there's issues with transparency and availability of state court proceedings and local court proceedings. So the availability of the raw materials of our democracy is a key issue, and I think it's an issue that Georgia needs to face. And again, not by lawsuits. This is something that is a perfect topic for hearings within the elected body of the representatives of the people of Georgia.
Yeah, that's a really good point. There's one more thing I wanted to let you know, and it was along those lines. Oh yeah. So we went and did a man on the street interview, so to speak, with senators and assemblymen. We interviewed about 6 of them. 5 were unaware that the General Assembly was exempt from its own Open Records Act. 1 was aware and thought that, and all said, when we asked should it be changed, they all said, well, the devil's in the details, I'd have to see the bill, that kind of thing. None took a stand and said, yeah, obviously, well, 1 suggested it should be open. But what's interesting is, one of the guys we approached was a senator who is appointed as he's the administration's floor leader. And I don't know if you've seen this in other states, but the governor can have appointed members of his own party who are sort of there to represent the governor on the floor of the General Assembly, or the governor's agenda, or the governor's slate of bills. And in Georgia, they actually, it's like an official position to which you're appointed as an assemblyman or as a senator. This guy, I asked him, I just want to ask you about transparency. And this is on camera. On camera, I said, we just want to ask you about transparency. He says, well, I'm not sure I can give you an answer. I need the questions in advance. And I'm like, what do you mean you need the questions in advance to talk about transparency? And his answer was, well, I'm here representing the governor, and I don't want to say anything the governor doesn't want me to say. What's interesting is the governor didn't elect this guy. The people elected this guy. And he's a senator representing a district, not a puppet representing the governor. Again, I don't want to go take any more of your time. It's just this whole sort of concept of opacity, and in addition to the fact that, I don't work for the people, I work for the system, or I work for my patrons in government. Does this again, pass the smell test?
You know, if I were interviewing a senator, I would show them a bill that they had sponsored and congratulate them on the bill and say, so who owns this law, Senator?
Right. Exactly.
It's the people that own the law. And it's the people that own the legislature. We are all servants of the people when we are in public service, and we just can't forget that.
Do you think that, and again, this is painting with a very broad brush, but do you think that many elected representatives have forgotten that they work for the people, that they are representatives of the people rather than they're there at the people's pleasure, so to speak?
I think a lot of representatives and senators get caught up in the day-to-day mechanics of their legislature, but I don't think they've forgotten they're there for the people, because they go back every couple of years and they have to get reelected. They're back in their district, they're kissing babies. They know who they work for, but then they get to Atlanta and they get in the middle of these long, complicated bills of procurement and, the complexities of insurance. And sometimes they forget where they came from. What's important about a case like being sued for publishing the official code of Georgia annotated is it puts these issues in sharp relief. And my hope is that members of the Georgia Assembly and the Senate will look at this court case and say, well, of course the people own the law. That's obvious.